I can't see how I can start the webinar. Oh, there it is. Welcome, welcome, welcome to our weekly Cello Law webinar. Let's give it a few seconds so people get a chance to join, and then we'll go ahead and get started. And we decided there was a lot of interest in not only going over some of the new changes that are taking place, but also talking a little bit about family-based immigration, because we're always talking about business-based, but there's an interrelationship, so it's probably good that we speak a little bit about family immigration. So I'm trying to do this from a new computer and trying to get the lighting right. So, but every week we try to bring forth strategies and not just tell you what the changes in immigration are, but also, tell you how you can apply those changes so you can achieve your immigration objectives. So let's go ahead and get started. So ways to connect with us. As I always say, we love connecting with you. And there are different ways you can connect. You can connect on Facebook, Twitter, Instagram, all sorts of different ways, because we love to hear from you. And by connecting with you, we know what issues are critical for you, and we're able to develop content that hopefully is helpful on your immigration journey. So if you've missed any of our webinars, you can always sign up for our YouTube channel. And if you do that, then anytime we update it with new content, then you'll be notified. Otherwise, you won't know when we've got new information that could be critical to what you're looking for. Now, to dive right into the family-based immigration, there are different pathways. There is, pathways for the U.S. citizen, pathways for permanent residents, pathways for non-immigrant visa holders. So we have to look at the different pathways and give you some tips as to, especially if you are thinking of or getting ready to, file for, getting ready to get married. It's good to understand how that marriage could really impact your immigration process. So there we go. So let's go ahead and get started. So marriage-based. If you are a U.S. citizen and you are thinking of embarking on a marriage-based process, there's always everyone thinks about the fiancé option. The problem with that is the fiancé option takes just as long as it does to file for permanent residence, through the other way. So we don't really see a big benefit. I mean, back in the day when it was first introduced, the whole purpose of that was so fiancés could enter the United States sooner, and then you wouldn't have to wait for a really long time. Now, one of the initiatives that President Biden has is to try to make sure that family-based people that are in the queue are able to enter the United States. That hasn't taken place yet, but I hope they do that, because I don't think people realize that it takes about 1.5 years to get through that entire process. Now, you will need to be married, and a marriage is valid if it's valid in the place where it's celebrated. So for most people, that would be, how it's celebrated in your home country. There are, if you're from a country where there are very different, types of rules regarding marriage, like for example, in India, You've got a Hindu Marriage Act, which says you've got to, in order for a Hindu marriage to be valid, you've got to go through the 7 steps. Well, that's not really true with Arya Samaj weddings or some other Hindu weddings in various localities where, the rules are slightly different. But it's important that, the marriage is valid if it's valid where it's celebrated. So if you are overseas, you file the I-130. Like I said, we're not going to talk about the fiancé process because I think that it's just so fraught with timing issues that it doesn't help. But the fiancé, you file an I-29F in this country. And then, as that process goes through, it gets approved, then it has to, anytime someone is overseas and it is a permanent residence or a subsect of the permanent residence process, it has to go to the NVC, National Visa Center. And then from the National Visa Center, you get the consulate interview. So from the time it's approved and it goes to the National Visa Center, it's about 6 to 8 weeks. And then the National Visa Center starts doing some of the preliminary process to get the petition approved. So when the K visa holder enters as a fiance, they've got 90 days in which they can get married and file their immigration documents. Now, if you're overseas, you file an I-130. I-130 gets approved. Again, like I said, it has to go through the the NVC, National Visa Center. And then, the foreign national gets called in for an interview. They will ask about things like who was at your wedding, how many people attended. And during COVID, that's been a really crazy stance because you have weddings that are not traditionally undertaken as traditional Indian weddings. And so that's something people have to look out for. But they'll ask questions about that. You'll take pictures. How did you meet? Some of the standard stuff. And they have on occasion reached out to like your neighbors to make sure that the marriage is valid. If there is some concern that they have that the marriage is not valid. And I want to remind everyone, please post your questions in the Q&A. And at the end, we'll have some breakdown with answering all your immigration questions. Now, so when the foreign national goes for the interview and the interview is approved, they get stamped with a immigrant visa stamp. So they take that stamp, and when they enter the United States, within 6 to 8 weeks, they get their, depending on how long they're married, if they're newly married less than 2 years, they'll get their conditional permanent residence. But when they enter, they get stamped with a 551 stamp, which allows them to work and travel for at least 1 year while they're waiting for their conditional permanent residence. If the foreign national is in the United States, you can file the I-130 and I-485 at the same time. And so within 5 to 6 months, they'll get their work authorization and advanced parole. Now, if the individual is in the United States on an H and an L, then you don't have to worry about the abandonment issue. But if they are in the United States on anything other than an H and L, if you depart the United States while the I-485 is pending, before you get your advanced parole, the application will be deemed abandoned. So that's something really you've got to be, worried about. Now, if you've been married for more than 2 years, you won't get a conditional. You'll get the actual permanent residence card. But for those who are married for 2 years or less, there's a conditional permanent residence, and they put that in place to make sure that there's no fraud. So, 2 years from the date of issuance, you have to file an I-751 showing that the marriage was entered into was bona fide, and then the conditions can be removed. Now, if you get your permanent residence through marriage to a U.S. citizen, You don't have to wait 5 years to become a US citizen. You can actually become a US citizen in 3 years. So right around the time that you're getting your conditions removed, shortly after that, you can probably file for citizenship. Now, here's some considerations that you should look out for. Of course, legal age, the person, if they were married before, you have to show that that marriage was terminated, because although in some countries, multiple polygamy is allowed, it is not allowed in the United States. So the rule is a marriage is valid as long as it's valid where celebrated, unless it's against a public policy initiative. And the United States has got a public policy issue with polygamy. So that would not be valid. You have to have proof of US citizenship. Then the big issue sometimes is financial sponsorship. So the petitioner, whether they have, the petitioner has to provide almost a contract with the US government that says, hey, I am going to provide financial support for this foreign national. And it's contractually binding. So you should really read the ramifications for that, because it's pretty steep. Now, if you don't meet the guidelines, and it's not really high, it's about 100 to 120, 25% of the poverty guidelines. But let's say you're a student and, you're studying now and you don't have an income per se, you can have a co-sponsor. You still have to file the I-864, but you can have a co-sponsor who can show that they have the financial ability to, make sure that the foreign national doesn't become a public charge. Now, you have to submit at least 3 years of, tax returns. So that's something you want to make sure that, you've got settled, and information about, your bank statements and other things to show that you do have the wherewithal, the financial wherewithal to support the foreign national. Now, the other thing is birth certificates. So you have to, the birth certificate, if you have a birth certificate, then it's fine. You want to make sure the birth certificate, whether it's a family-based or an employment-based birth certificate, was issued close to the time that you were born. Some people have been getting birth certificates recently, like they didn't get one when they were born, so they're trying to get one now, but it's dated now. So that's, would be an issue. So then you can submit, if you can't get a birth certificate, you can submit secondary evidence. Now, one of the main sources of secondary evidence is if your birth certificate was unavailable. Let's say you were born in a village, or you were born at a time where record keeping wasn't that critical. Well, you could submit 2 affidavits of support of people who have firsthand knowledge of your birth, and a certificate of unavailability, and it can come from the record keeping body, from the panchayat, any group that has responsibility for record keeping. But, those are the types of, and, you can also school leaving certificate, the Aadhaar card, a number of other things I would add on to that if you don't have your actual, birth certificate. The more you provide, the better. So, you want to think about that. So those are some of the documents that you would submit. Now, to get to the visa bulletin, the family-sponsored preferences are, F1 is for unmarried sons and daughters of US citizens. 2 is spouses and children, unmarried sons and daughters of permanent residents. F2A and the second preference is broken down with 2 categories. So F2A is spouses and children. So children are anyone under the age of 21 and of permanent residents. And F2B is unmarried sons and daughters who are 21 years or older of permanent residents. You notice that within these categories that a permanent residence can't per se sponsor their married sons or daughters. Only a US citizen can. So third preference is married sons and daughters of US citizens. And fourth is brothers and sisters. And the queue for brothers and sisters is about 15 years. So it's a very long time. Now, if you look over here, here are the final action dates. And, you can see that although in employment base, there's a substantial difference between the all chargeability areas, except for those listed, and usually India and China. But you don't see that much of a difference here in the family-based because of the way it's allocated. So you have F1, unmarried sons and daughters of US citizens with the priority date of October 22nd, 2014. The great news is F2A, spouses and children of permanent residents, are current. That doesn't often happen. So that means that if you're a permanent resident and you're looking to marry, let's say he or she's on a student visa or an H-1B visa, that means that they can adjust status immediately, which was not the case, some time back, that, there was always that queue. So that's really great to think about right now. If you're thinking about getting married and you're a permanent resident, this is a very good time to do it. And of course, you've got the unmarried sons and daughters, and married sons and daughters of US citizens are August 2008. Wow. And of course, brothers and sisters of adult US citizens is 2006. So there's, like I said, a major wait. So we talked about this, the work authorization that you would be given and permission to travel. Now, if you don't want to adjust status in the US, you can always do consular processing. And that consideration comes into play. Let's say, for example, you're here on an F1 and you're finishing the end of your study, or you're finishing your OPT. You want to go back to your home country to plan the wedding and everything else, and you need some flexibility in order to travel. If you file your I-485 here in the US, that will bind you for a while, so you won't be able to travel as easily. So in that instance, it's probably better to do consular processing because you're going to be home for some time. But otherwise, unless you're on an H or an L, you have to wait for your advanced parole before you can travel. So I'm a US citizen and my fiance lives abroad. Where should we get married? What should we do? So the K-1 visa, you get married in the US. I-130 consular processing, and then you get married abroad. Now, if for some reason your spouse comes into the US, let's say, you're not sure you're going to get married and you're dating, and your person that you're close to is coming over for a visit, and they come on a visitor's visa, and then things just accelerate rapidly. You think, okay, we're going to get married. We're going to get married now. You change your mind. You weren't planning on it, but you change your mind. You decide you're going to get married now. A couple of things. On a visitor visa, you cannot, for 90 days, do anything to initiate any type of process that would deem that you had a previously preconceived intent to file for permanent residency at the time of your entry. And so you don't want to do anything for 90 days. But after 90 days, if you didn't enter on that purpose and you changed your mind, then that's something you can do. And then you can get married in the US and file for an I-140 485. Now, some of the nuances of that is, okay, my visitor visa expires in 6 months, and if the process isn't approved in that time frame, what can I do? So what you can do then is you'd continue to extend your visitor visa, but you are perfectly, as long as you didn't do it within 90 days, you're permitted to stay while this process continues. So that's something to think about. Happens a lot with parents. The parents will come over and not sure if they'll like the United States, and then later, they want the son or daughter U.S. citizen wants to sponsor them. So these are some of the things that you've got to keep in mind when you're doing that. So a K-1 visa, as I stated, you file for the fiancé visa with the USCIS. It goes to National Visa Center, and it goes to the embassy, and they review the documentation to make sure it's a valid, fiancé. And they do recognize arranged marriages, so they understand that does take place. But some of the things that you may submit are communications you've had, your WhatsApp messages, your emails, pictures you've sent each other, things like that. And then when they enter the US, you have to marry within 90 days. But like I said, the K-1 visa takes about 9 months. Last we were counting. So it's almost as long as the consular processing marriage-based. But it just may be that you can't get married because of COVID and travel restrictions. So in this instance, this would probably be, a mechanism that you'd want to use. So when they come into the US, they actually file the 485. There'll be an interview where you've seen these movies where, the officer will ask questions about the bona fides of the marriage, and then the conditional permanent residence is granted. And then you've got 2 years, you file the 751, showing that it was in good faith, and you may have another interview at that time. Likely to spend less time apart, not substantially, but I think it's really a good process during this COVID time because of the travel restrictions. Otherwise, like I said, it is pretty much you shave off a couple of months, but in the other way, they'd come in as a permanent residence. So what type of evidence? Like I said, showing that the marriage is bona fide. You can get affidavits from friends and other people, show your communications, social media, anything to show that you've been talking. Now, back in the day, people would write letters or they'd have to call, so they'd have their phone records. Now with WhatsApp and all sorts of, I think there's a ton of other ways in which you can call through the internet. You may not have them, but taking screenshots of that and other things would help. And you can there's ways in which on most of those applications that there's data that's stored on the person that you communicate with the most. And so that's another thing you could show as evidence that, of all my contacts on WhatsApp, here is, the evidence that this is the person I communicate with the most. So they have that for most of the, internet-based communication devices. So I think that's also a good way in which you can show that this is the main person that I talk with. Now the I-130 485, like we said, you do have to get married for that. And it has to be consistent with the laws of the country. And only then can you file the I-130. And then once it's approved, the I-130 gets forwarded to the National Visa Center. And then they get set up for the appointment with the consulate. for consular processing. They still want to see the bona fides even in those instances. And like I said, if your wedding is slightly untraditional, you may want to talk with an attorney beforehand, or get letters from family-based attorneys in your home country to say that even though it's slightly different from the standard, it is still valid in our country. Now, even with this, you've got to remove the conditions. You can file 90 days before the 2-year expiration, and you have to prove that it's a good faith marriage. What happens if there's some issues and, during that time, you can either get your spouse to sign on saying that it was bona fide if you both have a good relationship, and you're divorced, then it's okay to proceed. The problem is if you're separated, that becomes a bigger issue in trying to get your conditions removed. So get married faster on a K-1 path, spouse must wait abroad after marriage, lower denial rates, and no K-1 fees. So adjustment of status in the US, like I said, you can do this not only with a US citizen, but now you can do this if you're marrying a permanent resident, because there is no, it's current right now. And you've got to keep checking. It may not be current next month, but it's current presently. And so that means you can file the I-130 and 45 at the same time, which is great. Remember that I'm going to say it again and again, if you're not on an H or L, you can't depart until you get your advance parole. So that's something you may want to take into consideration. And we talked about the 90-day presumption rule for visitors. That rule doesn't apply to H's and L's. It only applies to other non-immigrant categories. And for the most part, it's pretty much the visitor visa. So what type of evidence? You want to show that you've got to show your financial records, because you've got the US citizen spouse or the green card holder spouse has got to file the affidavit of support, birth certificates, not only yourself, but any children if they're applicable, documentation of the wedding, affidavits, pictures, gifts you've bought, maybe trips you've taken. Those are some of the things that you would show that it's an actual bona fide marriage. Now, recently somebody asked me, well, we're both in school, I'm doing my residency, we're not living in the same place, is that going to be a problem? No. You would have one primary residence, so that may not be where the school is. It may be wherever the US citizen would deem their primary residence, whether it's your parents' home, or if their spouse is working someplace else and they're doing a residency someplace else, maybe it's where the spouse is living would be their primary, place that they're living. But that in and of itself, as long as you've got other information about the bona fides, should not be a problem. And so, yes, mainly it's about the legitimacy of the marriage, right? So they just want to make sure that it's bona fide. How did you meet your spouse? Tell me about your wedding. When was the last vacation? And it also depends on, there's some cultural things that are innate in the questions that they would ask. If you've had an arranged marriage and you're from a pretty conservative culture, you probably wouldn't have taken a vacation together. And, you're just getting to know one another as this is going on. So they will, modify their questions based on the cultural aspect as well. Cross-chargeability. Now, this applies not only for family-based, but this applies even for employment. What that means is cross-charging is you're saying, hey, my spouse is, I'm from a country where there's a backlog, but my spouse was born in Australia, or some other country where there's no backlog, you can use your spouse's country of birth and cross-charge it with yours and get a benefit from the fact that they are born in a country with less backlog. So that's great. As long as you're filing your 485s together, you'll be able to leverage your spouse's, cross-chargeability. And so for those of you who are not married yet and are looking, maybe that's something you want to keep in mind if you're in the permanent residence process. Like I said, it works not only for family-based, but it works for employment-based as well. Yes, you want to think about all these things when you're talking about, we're going to see, there's some countries like India where COVID is, there are a number of countries that have already instituted travel bans. And I think the US is going to follow suit very shortly unless India gets a control of their COVID numbers. So those are some of the things that you want to look at, because not only is there going to be a travel ban, but that also means that consular services will be limited in those countries because of, the pandemic. So K1, 5 to 9 months, 20 to 30 months at another. It is, like I said, if you compare that to the I-130, for me, it doesn't seem reasonable unless you're dealing with a travel ban to go the K1 route. And, you have to look at a number of things. I mean, you want to figure out, do I have to depart? I've had tons of spouses that have said, oh, I've got to go back and I need my advance parole now. Well, you can't expedite advance paroles anymore. So if you can't wait for that because you've got travel plans and other things, then you may want to do the consular processing route instead of adjusting status in the US. So these are a number of the considerations that you would take to balance which process you think are innate. So spouses of US citizens or permanent residents are exempted from the geographic proclamations. Those were those, Europe, other countries. And then there's a national interest exception for fiancés, but we don't know with any new travel restrictions, especially if it's based on the pandemic, how that will play out. DOS acknowledges there's a backlog of 473,000 immigrant visa cases at the National Visa Center. And this is just at the NVC, so it doesn't even include those that are held up at the embassies because of limited staff. There are emergency and critical services that may be into play, but, even though they're prioritizing immediate relatives and fiance visas, like I said, it all depends on the country conditions and, how that's progressing. So these are some of the things I want you to keep in mind as you are embarking on a family-based process. This is our Chala forum. If you haven't joined our forum, please do. We put out all sorts of critical information on the forum. There's one for H-1Bs and H-4s, but really it's a general immigration forum. And then there's one for our friends, our Aussie friends at the EU, in Australia. And my team will be putting up the links for that. Connect with us on a number of different areas, and you can review our previous recordings. Next week, we're going to talk about RFEs. RFEs. What should you worry about on an H-1B? What are some RFEs? What are some RFEs related to maybe an I-140 you've got pending? what are some RFE issues for adjustments? So it's going to be raining RFEs next week. If you've got any of these applications that either you're getting ready to file or that are pending, you certainly don't want to miss our next, the webinar for next week. If you've got any questions, email us at info@cellolaw.com, or if you have any suggestions as to topics you want us to cover, we'd love to hear from you. And I'm going to invite our moderator now, so we can.
Hello. Hi, Lakshmi. Good afternoon.
Can't hear you. Nope, you're on mute again.
Can you hear me now? How about now? No?
Maybe you should check your settings on your computer. So as
Okay.
we're waiting for our moderator to log in,
Yes, I can hear you both.
I think we have
They are saying they can hear.
posted Shaker?
Can you hear me?
You're not, I don't have you on mute. Oh, they can hear. Okay, people can hear me. I think the audience can hear Shaker. I just think I can't. So let me see if it's my. Hello, hello. Okay, now I can hear you. Maybe maybe I just needed to test it, I guess.
Can you hear me now?
Yep.
Okay. All right. Let's see if here. Hi, good afternoon, everybody. Thanks for joining today. I'll be taking the questions on the Q&A box. And if your attorney is asking for a clarification, appreciate you responding to that in the chat, because it just makes it easier for me to go look at the chat and then relay that information to her.
Right.
Okay, let's begin. You all right?
Yeah.
So the first question is from an anonymous attendee. My son is more than 21 years of age.
Mm-hmm.
Once I get my green card, will I be able to apply for him in F2B category, or do I have to wait to be US citizen to apply for him?
Okay, he's over 21. As long as he's not married, you can go ahead and apply for him as an unmarried son or daughter over the age of 21. And then when you become a US citizen, if it's still pending, you can, upgrade it to the green card category.
Okay. This next one is from another AA. He's got 3 questions, long questions. So I'm going to read one at a time. My fiance and I are planning to have a court wedding soon. would that be acceptable for the purpose of filing the green card petition rather than a traditional Indian style wedding, which we want to avoid doing due to COVID?
Yes, you can. And the only thing I would encourage you to do is then just make sure that you have other evidence of your bona fides, like pictures you had together. Explain that because of COVID, you're going to have the ceremony later, especially because if you are from India, because of the instances of COVID are really high there. So, it's absolutely fine that you marry through a court wedding and submit that.
Okay. Next one, his same person. Also, what do I need to show in terms of finances? I'm on an H-1B status for over 7 years now. So do I need to show my own tax returns in addition to my fiance, the sponsors? And does the amount of time I've spent on H-1B status affect the amount of finances that either me or my fiance would have to show?
So who is a US citizen?
I'm on H-1B, I guess fiance, the sponsor, so it must be that person who's in.
Okay, so you can use your salary as well, but the 864 would be dictated by the petitioner, which would be your spouse. Now, if your fiance doesn't have a salary per se, then she'd still have to file the 864, and you'd file another one showing your salary.
Okay. Finally, what is the 40-quarter rule? I have completed 30 quarters of Social Security employment out of the 40 quarters that I believe are required. So what happens with regards to the remaining 10 quarters? Would my fiance be financially liable for me not being a public charge only for the remaining 10 quarters or for the 40 additional quarters from the point the petition is received?
Yeah, those are two separate issues. The Social Security issues are separate from the I-864 issues, which deal with the affidavit of support. So yeah, she'd still be on the hook for 10 years regardless. That doesn't mean that you would necessarily, let's say you God forbid, you separate ways, that she would be on the hook. It's only if you file for her to be on the hook that, she would file for you. You would try to go after that would be an issue.
All right. So let's go to the next person. Kumar. My son, who is an F1 OPT, not married. If I get my marriage-based green card, my marriage is less than 2 years old. Can I file for him, and under what category does he fall?
Can you say that again? He says son.
My son, who's on F1 OPT, is not married. If I get my marriage-based green card, my marriage is less than 2 years old. Can I file for him, and under what category does he fall?
Right. So you're getting your green card, and then you would file for him. He would be the unmarried son and daughter of a permanent resident who's over 21.
Okay. Just trying to juggle these. All right, Satish Raela, sorry. I have completed 4 years bachelor's degree in US, and I'm planning to do master's. While studying master's with F1 status, can I apply H-1B with bachelor's degree?
Yes. As long as it's equivalent to a US 4-year degree, yes.
All right. Kumar again says he's 22 years old now. The F1 OPT, not married. So
Right.
I don't know if it makes any difference.
Yeah. As long as he's not married, because he'd be a son and daughter of a permanent resident over the age of 21.
Okay. Next one is Loveleen Sandhu. Arranged marriage. Guy is in Canada. I am United States citizen. Will it be better if I go there, get married, and file his paperwork, or will it be better he comes here?
So she is on, say that again. These questions are so,
Arranged marriage. The guy is in Canada.
okay,
I am a United States citizen.
okay.
Will it be better if I go there, get married, and file his paperwork, or will it be better if he comes here?
Well, remember, if he comes here on a visitor visa, you've got to show that he didn't have the preconceived intent to come here to get married and adjust. But if he's coming here just to see you and you then decide to get married, as long as you don't do it within 90 days of entry, then you're okay. Or, if you can go to Canada and, if he's got a job and he's working there and he can't leave his job, because if he comes in to the US, he can't depart until the advance parole is issued. That may not be feasible. So in that instance, you would go to Canada and get married and file for consular processing from there.
Okay. She's just she says did not meet him in person in last 2 years, spoke over the phone calls, one video call so far. Families know each other well. I do have veteran status, not sure if that helps.
I don't think for the purposes of this, but I was just going to say that as long as you can show that it's bona fide, right? So you would show that the families know each other, that you are talking with one another, and get affidavits from family members, from friends, anyone who could attest to the bona fides of the marriage.
Okay. So another one, next AA question is on U visa. I encountered aggravated assault and robbery 3 years ago. Do I qualify for the U visa?
It is one of the categories for the U visa. You'd have to get the form signed off, because it was 3 years ago, by either an officer or a judge, to say that you were helpful in this process. So that would be the only thing, because it's been 3 years. Would you be able to get that signature from either the police official or a judge saying that you were helpful?
Okay, the next one is from Srini Rao. When can I expect receipts, those filed EB3 I-485 mid of March?
I think my team can probably send something out to tell you when the receipt notices. But what you can do, if you filed it mid-March, look out for your checks that you submitted with that. Because once the checks are cashed by the USCIS, on the back of the check, they'll have the receipt number. So at least you'll have the receipt number. So that's one thing I would look out for.
The next one is another AA. Thank you for the webinar. I have 7 public drunkenness non-traffic citations that I have not cleared. I'm in the process of filing for asylum. Do I have to mention these? Yes, will that get me disqualified or referred to immigration judge? I have a substance abuse issue, alcohol, but I am better now. I was in rehab before. I intend to clear these charges through.
There are, issues with relating to, depends on the citation, the number of them. because you had so many, does that give rise to, whether it would be, it's clearly a crime of moral turpitude, but, was it a misdemeanor in that particular jurisdiction? And then, because you've been rehabilitated, you've gone through rehab, that would help address any concerns that they would have about, because remember, if you had looked at our webinar where we talked about the expanded discretionary calculation, so that's one of the things that they look for if you've had public drunkenness. But, they also say that if you've gone through rehab and taken care of that, it should be okay. But it will be an issue. You've got to answer the asylum questions correctly. I would make sure your attorney knows about it, and they can make sure that they present it in a way that would be most favorable to you.
Okay. Next question is from an AA. Hi, Lakshmi. I'm working for company A since 2016 as a lead associate in US, and now company B wants to hire me as IT manager. The question is, what are the legal chances that I'll be qualified for EB1C, as I do not have any prior experience in either managerial or executive positions?
Right. For an EB1C, you have to have worked for the overseas entity as an executive or manager for at least 1 year before you're eligible to file an EB1C in the US, because it's an intercompany transferee. So the mere fact that you're an IT manager doesn't, that's part of it. But the more critical thing is you have had to have worked for the overseas entity.
All right. Next one is from Mariangela Bossi. Good afternoon. I have a different question, if it is possible, not about marriage. My
Sure.
son is asking if it is necessary to come back to the country of origin, which is Italy, to have an interview at the American Embassy asking for a J1 visa. He's now on a F1 visa. Thank you very much.
You can change status to a J1. It would be done on the I-539, but it takes a really long time and there's no premium processing. One of the things that he may want to look to see if he's eligible to go to Mexico and process the J from Mexico. And we had a session on visa processing in Mexico, which includes a contact information from a resource that helps people with processing in Mexico. So that may be a faster route.
All right. Okay, next one is from an AA. I am on H-1B visa and my daughter is on H-4 visa. If I get married to an American citizen in next 3 months, and how can I help my daughter to get her green card, and how long it may take approximately?
Is the US citizen planning on adopting the daughter?
You can answer that in the chat, so it makes it easier for me to relay the information instead of in the Q&A box, please.
Yeah, and if you want, I would email that question to info@cellolaw.com, because there's some nuances to that, and I want to make sure that you get all your options. So your daughter's taken.
I'm not sure if the person, because it says AA on the question box, and it has a name in the chat, and it says yes. And of course, I think it is. It says she can be adopted.
Okay, so why don't you email us, and I can tell you what the process would be if the US citizen is willing to adopt the child.
All right. Next one is from another AA. Thank you guys for these sessions, for throwing light on the immigration issues. Question, me and my husband got married in Pakistan, nikah. over video call, but our marriage is not registered yet. He's in the United States, asylum approved, waiting on green card for the past 2 years, stuck at a Texas visa center. We are waiting on his green card. I'm currently on my change of status from B2 to F1. Can we register our, I guess, marriage once we receive his green card?
Now, if you're on, I don't understand, if you're on an, if you're changing from a visitor to an F1 and he's in the United States on an asylum application, pending his green card, why did you have the NICA via Zoom?
Well, let's see if you can answer that, Ms. In the chat box. Due to religious issues.
Okay, but you still have to get, in the United States, you'd have to get the marriage registered. So you're probably gonna have to do a court marriage anyway, in addition to, even though you had the NICA done online so family members could be a part of it, you're probably going to have to do a court marriage because the officiating person, I would imagine, was in Pakistan. So what I would do is to do a court marriage as well. And so you have both.
All right. Another question from Loveleen Sandhu on arranged marriage. If I do court marriage and come back to States, file his paperwork, his study will finish in August 29. Then he can try for visitor visa. Is this the person getting married to somebody in Canada?
Oh, yeah. The problem is once you're married, when he tries to enter on a visitor visa, they'll ask him whether he's got any relatives here in the United States. And he'd have to say, yes, I have a citizen wife, and they may not allow him to enter. So if he's planning on coming in August to go to school, then you may want to wait till after that time to get married.
All right, this person who is called Nikah done in Pakistan, she wants to know, you said to get court marriage here again, or she says, when do you think is the best time to do it?
Do it when, I certainly wouldn't wait till before the asylum application is complete. I think you could go ahead and do it now, whenever it's feasible, depending on where you and your spouse are currently staying.
All right. Satish, I got your question in the chat. I'll take it in the same order, time-stamped order, but I appreciate if y'all put the questions in the Q&A box. Satish, just leave the question in the chat. Don't put it in the Q&A box again. Next one, Srini Rao, I think, is following up. Any chance interviews are getting waiver for EB2, EB3, I-485?
I think they will be. There's no official pronouncement of that, but it's highly likely. So stay tuned. As soon as we hear anything, we'll let you know.
All right. Next question is from AA. How long does it take to get a work permit after filing for U visa? And do you guys assist with U visa applications?
We do. There's a tremendous backlog for U visas right now, or there has been, since the beginning of time. So it takes a very long time to get it takes quite some time to get the work authorization. At one point, they were allowing work authorization. I think it was on the approval notice, so you didn't have to apply separately, but even to get, once you file the U, it's even hard to get an update on that for a while, but yes, we do assist with that.
All right. This next one says, how far the EB2 dates can go in October 2021?
I think we had a predictions last, and I think we've got some new pronouncements from Oppenheim. Mac, you want to put those links up, or Kara?
All right. We'll take the question from chat from Satish D. My son wants, he's on a student visa, marry a girl who already has a green card citizen. I guess he wants to know the procedure maybe. So his son is on a student visa here and wants to marry a girl who's already a green card. Satish, are you from Pune? Did I meet you in one of those conferences? Your name looks familiar. Anyway, so I think that's what he's asking. Satish,
Right.
if you want, you can clarify in the chat.
Um,
Yes, he says yes.
Well, here's the thing, Satish. You said green card citizen. I'm thinking you're thinking either green card or citizen. Right now, green card holders, it's current for spouses and children under the age of 21. So if you were to marry a green card holder, you'd file the I-130 and I-485. And within 5 to 6 months, he would get work authorization, advance parole. Remember, he can't depart the United States, whether he's marrying a US citizen or a green card holder, until he gets the advance parole. Otherwise, it would be deemed abandoned. But the process would be the same for either right now. Please remember that green card holders, in the past, there has been a backlog. So you'd have to check the visa bulletin, as you're checking out your options of whether you want your son to marry a green card holder versus a US citizen, to see what the time frame would be.
Okay, I think that's all I have.
Great. Right in time.
Yeah.
Well, thank you all for joining. If you are new, I put a poll up. If you get a chance, you can respond to that unanimously. I want to thank my team for putting this together. Next week, we're going to talk about RFEs. So if you have any type of application pending, it is a good time to tune in to find out what the strategies would be in case your application or petition is RFE'd. And want to thank Shaker for doing a great job on moderating. I hope you all are safe. I hope everyone's getting vaccinated. That's the key for all of us to resume our normal activity again. And please join us on our Telegram group if you have not. Share, if you found this helpful, please share our webinar details with your friends. We'd love that. And I look forward to seeing you all next week.
All right. Thank you, Lakshmi, for the opportunity. And thank you, everybody out there. Stay safe and stay classy. See you next week.
Bye.
Take care.